The most common contractual mistakes. Episode 5. A quick look at agency agreements. Part of the series Global Business Law in 20 Minutes with me, Federico Vasoli.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent.
Hello and welcome. I am Natalia Łowska-Czajka, advocate mediator from Warsaw, representing both oplawyers.org and instantmediations.com.
And hello, everybody. I'm Federico Vasoli, managing partner of the MTV Global with offices in Singapore, Malta, and Vietnam. It's great to be back.
Thank you so much, Federico, for wanting to be with us today on the topic that actually sounds a little bit like from the movies, because we're going to talk about agents. And when we say agents, I do mean it within the legal framework. And I know, just being an European Union citizen as you are, that European Union has a lot to do within the legal framework of what agency agreement is. So can you tell us what this is and what does European Union provides in terms of regulations for agency agreements and agents?
Absolutely. Thank you, Natalia. Yes, we are a special breed in this field in the European Union because we have a directive. Now, for our non-EU viewers and listeners, the European Union issues norms, we cannot really call them law, that are called directives. There are other forms of norms issued by the European Union legislator, or legislators better, that are regulations and decisions. But without going too much into these details, the main difference between the two, which is very important in this field, is that a regulation is immediately applicable in any member state of the European Union. So what happens at a European Union level is that the legislator decides on something, they discuss a topic, and eventually they issue a regulation which is immediately applicable and enforceable in the 27 member states of the European Union. There could be exceptions, but let's not get into that. So the European Union issues that, and it's law in each member state of the European Union. On the other hand, directives are not immediately applicable in each member state. They are, as the name suggests, a directive so that the individual member state can either adapt its existing legislation, which is often the case because sometimes directives are based on existing legislation that exists in some individual member states, or it is an indication for the member state to enact new pieces of legislation that goes in the direction of the directive. So this is the case of the directive on commercial agents. It's an old directive, decades old, but it has massive meaning for the member states and businesses in the European Union, and also for those of you that are not in the European Union. If you do business in the European Union with agents there, then it is likely that you will apply the European directive. Now, what does the directive says? First of all, being a directive, it means that every state has its own legislation on agents, on commercial agents. So heads up, you might see differences in Polish law, for instance, between Poland and Italy, Italy and France and Spain and Germany and so on and so forth in all the various member states. Because again, it is a directive. So every individual member state issued its own legislation on commercial agents. But essentially the idea is to protect agents. Who are agents? Outside of the European Union, agents, broadly speaking, of course, there must be some country that has specific norms defining the role of an agent, is a relatively vague term. Is a representative, is somebody that represents a business and essentially promotes the sales of products and services of the so-called principal of the company in a certain territory. This is the definition of commercial agency in the European Union, with more characteristics, with more features. So not everybody can be an agent. You have to be a business. Whether you are a company or an individual, you have to still be a business. So if you're an individual, you have to have, for instance, a VAT number. It cannot be just a sporadic activity that you conduct from time to time. And then the essential aspects of the directive are those linked to the remuneration of the agent in terms of indemnity, and those pertaining termination. Now, what do I mean by indemnity? I mean that if an agent has worked for a principal for a certain number of years, at the end of the contract, for whatever reason, the agent will be entitled to a certain remuneration called indemnity. That could be triggered either for non-performance of the agreement, but also in certain cases for termination at will, or simply because the agreement has expired. And it is very important to know that, because we might have some principles from the US, from Singapore, from other countries that get an agent in the European Union, and then after 10 years, they have to pay an astronomical amount of money to the agent unless they agree otherwise, as an indemnity for termination. And the same applies to termination itself. That is, you cannot just terminate the agreement at once, at will. You have to terminate it, giving a certain advance notice depending on the number of years that the agreement has been in place. So these are the basic details of the directive. It is a hot topic in the European Union. There are other contractual forms for other types of professionals, such as procurers, such as distributors, such as representatives, such as dealers. All these are different contractual forms. So the key point of this episode is really that in the European Union there is an attention to fine details when it comes to this type of activity that in other countries in other jurisdictions is not as detailed as it is in this part of the world. Sorry for the super long answer. But do add something from Poland, Natalia, if you
I
will.
I do want to do that, and thank you for that. And also, talking about again about the directives, this is absolutely a brilliant instrument because within the discussion whether the European Union doesn't go too far or too much within the systems, the directive binds us to the effect. So the
Yes.
directive provides for the effect that needs to be achieved. But you are given, as a country, certain methods. You implement the directive. So the key word is implementation. And for example, the directive on the agents has been implemented by providing a special chapter into the Polish Civil Code, into the contractual part of it, when different parts of contracts are being named and described. And my practice so far has been dealing with individuals working for insurance companies. And I
Okay.
need to tell you that it was absolutely vital for these people to know their rights, to know what sort of provision they can claim, upon which conditions then they can be given notice as to further cooperation. So I do see the protective role of this directive stemming from already national law, because the directive is there, the implementation is our country law that everybody can read in Polish within the civil code. But speaking about it, I understand that since within the European Union we more or less know what we are talking about, have you, Federico, in your international practice, encountered cases, instances where people were not really knowing what they are talking about in terms of agents? So, was this term understood differently in different countries, different jurisdictions?
Yes, absolutely, Natalia, and I'm sure that the same happened to you. In fact, it is happened several times, and it also led to litigation. Um, it is a very old case, I remember, between an American principal and a German agent, where in that specific instance we defended the German agent, and the agent essentially had the right to a higher compensation upon termination. The American principal did not know what the obligations were. So they essentially wanted to terminate the contract, giving the agent, I don't remember if nothing or a very small sum compared to the essentially to the, this is the directive definition. I'm not sure I'm using the exact words in the directive, but essentially vis-a-vis the business generated by the agent himself. So the agent had generated more clients to the principal in a way that the principal could continue its business in Europe without relying on the agent anymore. And therefore, this economic advantage had to be somehow shared in proportion based on the number of years that they had the contract together with, on the percentage, on the commission that they had agreed in the contract. But essentially, the directive's spirit is to remunerate the agent for the creation of more business that will be beneficial for the principal. And this was ignored in this case by the principal. So we unfortunately we had to go to court, and but luckily we won. Luckily also for the client, we won the case. So the client, the agent, got a significant amount of money from the principal. This actually makes me think about another aspect about the commercial agency in Europe, in the European Union. Actually, the term Europe is not so incorrect, because the UK has implemented similar legislation back in the days when it was part of the European Union, and I assume that they will not change it so fast, but this is just my assumption. And Switzerland, which is not a member of the European Union, has a very similar piece of legislation on commercial agents in Switzerland. So this is good to know. But aside from this, the other important aspect is that generally, it is not always the case, but generally the agent only promotes the business of the principal. It is not an independent business that buys and sells and resells the products or services of the principal. That is the distributor. It's a different type of agreement. So it is important to pinpoint that. But yes, to answer your question, I mentioned this case. Yes, it has been something that we witnessed directly, that non-EU companies were not really aware of what they were doing, especially, once again, we link back to the previous episodes of this series, when they didn't have a proper agreement in place. Because the directive steps in. Of course, the spirit, the effect of the directives are unfolded not only in the legislation of individual member states, but also on the terms of the agreement. So you cannot go, the contractual provisions cannot go against the spirit of the directive. But having said that, the directive steps in, like any piece of legislation, when you don't have a proper agreement in place. So we go back to episode, I think, 1 or 2, when we mentioned the essential aspect of doing business, especially internationally, but also domestically, have a proper agreement, written agreement in place with a proper governing law and jurisdiction clause and so on and so forth. This is, we cannot repeat it enough. And watch those episodes if you have missed them.
Thank you for that, and for linking these stories that we're telling together. And now back to what is the most important part of drafting the agreement or having the agreement in place, especially when we're talking about, let us say, an agency agreement between an entity within the EU and entity from outside of the EU anywhere in the world. And having said that, can you tell us what ideas, suggestions you would have as to how to draft and include both jurisdiction and applicable law into such agreements? Because I'm sure we don't want to discourage people from having agency agreements. It's, I understand, to bring awareness of what sort of legal meaning it might have.
Oh, absolutely. It is actually, let me stress the importance of commercial agents for a non-EU business. It is a very light form of investment, in that the agent will carry out their activity with their own means, with their own organization. So yes, the principal will have an obligation to provide support to the agent, but there will not be technically a direct investment from the principal into the country, into the territory where the agent is working. So it is a big advantage for foreign companies. Essentially, you're operating in a territory without having to set up a new structure, without the hassles of accounting, taxes, and so on. So it is really good. Well, taxes to an extent, because if you sell service and products in a territory, possibly you have to pay at least VAT if you sell B2C, but that's a different topic. But in essence, what I'm saying is, it's a light form. It's a very easy and practical way to do business in the European Union, in this case, without having to set up a massive structure, employing people, and all that. So the clauses that are choosing jurisdiction and governing law and jurisdiction can be a bit tricky in that. It depends on whether you are the agent or the principal. Let's assume that the principal is a non-EU entity and the agent is an EU entity or a natural person. But let's call it entity for to make things simple. It depends normally on the territory that is covered by the agent. Now, this is tricky because a single agent could cover more than one jurisdiction. So in the example before, the German principal could appoint an agent that would promote the products and services of the principal itself in both Germany and Austria, to make things simple, two German-speaking countries, both members of the European Union. Now, do you apply German law or do you apply Austrian law? The devil is in the details. Honestly, I do not know how much German legislation differs from Austrian legislation on the matter, but it would be worth going through them with a German lawyer and an Austrian lawyer or both to see what the difference between the two is and what is more convenient for the parties. Again, we're not talking about imposing one's will. We're talking about negotiating an agreement which is fair and that both parties like. So this is where I use the term territory and not jurisdiction. If you have an agent that only covers one jurisdiction, so in the example before, the agent only works in Germany, then of course you apply German law. Well, not so much, of course, but it is reasonable to apply German law. I wouldn't see why you would not use German law and why you wouldn't go to court in Germany. Then again, things get even more complicated because Germany is a federal nation, is a federal state. So would you go to court, to the federal courts, or would you go to the Länder court, or I don't know. But this is why we exist. We're lawyers to try and interpret things, facts, and the law. But yes, I would, in a nutshell, I would apply as governing law and jurisdiction that of the agent and of the agent's territory. That is the simplest thing. In terms of other clauses, I would be very careful in drafting an agreement that abides by the terms at least of the directive and ideally also by the terms of the local legislation, if the local legislation is stricter than the directive. There are instances where the directive sets the bar, but individual member states apply even tighter rules than those fixed by the European Union. So I would be very careful. I would check the applicable law, and I would make sure that, for instance, the termination clause and the commissions clause, the indemnity clause, they're all parametered to such legislations, namely the content of the directive and the exact content of the member states' legislation on commercial agents. These are the two main topics.
Having said that, I do believe that we managed to persuade our listeners and viewers that being an agent, having an agency agreement might be an absolutely interesting journey through jurisdictions, through legal professions, through other professions that can be subject to agency agreements. And in any case, absolutely, as you can see, when you want to enter into an agency agreement, either being an agent or being the principal, please consult a lawyer. Having said that, see you in the next episode. Bye.
Bye-bye. See you. Thank you.